Dr. Rejman, you've told us that part of your role involved attendance at meetings of UKHCDO, and you've explained why, as it were, a conduit for information sharing, as I understand it. There's one particular document I just wanted to ask you to look at. It's DHSC 0003986_064. It's a letter that was copied to you, but it refers to what's said to be your view. So we can see it's from Dr. Pickles, by this time in 1995, no longer working for the Department of Health, but an acting consultant in public health, to Dr. Doyle at the Department of Health. And if we just look at the third paragraph, and the context we can see from the heading is supra-regional services. So I anticipate that was concerned with the question of whether there should be a supra-regional haemophilia service. The third paragraph says this: whilst professional consensus sounds like a great idea, and then it's a reference to you, Dr. Rejman, will tell you how the haemophilia directors club together and provide a united front to defend even the use of unlicensed drugs and completely disregard cost considerations. Now, what I wanted to ask you, Dr. Rejman, really is, did that accurately reflect your assessment of the Haemophilia Centre directors, and whether you can give us a little more background and context as to why that was your view?
I think I mentioned in my reply to the question, in my statement, that in essence the haemophilia directors were people that tried to get the best for their patients. The number of haemophilia patients across the country was a small number. I can't remember how much it was, 4,500, 5,000. And particularly in the reference centres, which then became the comprehensive care centres, they had, sometimes they might have 200, 300 patients even. So a significant proportion of the total UK haemophilia population. And they did everything they could for their haemophilia patients. At every juncture where it was a case for asking for money for this, for that, or whatever, or to raise the profile of haemophilia, they did it. And I think she says there that they provided a united front. Well, yes, they tended to. I mean, say the reference centre directors were a small group, I can't remember, 12, 13 people, who together would come together and say, look, we really must have a go at DH about this or that or the other. You know, we must get more money for this or more money for that, or spending, whatever. And a lot of it was down to finance, ultimately. And they would actually, quite often, with the drugs that were being used for haemophilia, and I'm not talking here about cryoprecipitate or plasma previously or anything else like that. What I'm talking about is concentrate. When it came to concentrates, there were a number of different commercial companies involved, as well as the Scottish fractionators from PFC, and obviously the English fractionator from BPL. So I can't remember how many you would have had, I don't know, well, more than half a dozen anyway. And they were forever trying to push their product. So forever they were putting in more research, more research, more research. How can our product be better than our competitor's product? Usually from the point of view, you know, safety sometimes, but a lot of the time it was a case of, can we make it easier to use? Does it dissolve better? Does it give a higher number of units in a smaller vial or whatever? So they're forever trying to improve. And so as a result of that, you would have a lot of products were being trialed. I said in trials, they might even be in trials. They may have been named patient situations. And they're forever pushing, pushing and pushing. And obviously, when a new product comes on stream, then they wanted it to be used. And so quite often it will be being used before it had been licensed. And there was there's that reference to Dr. Wynyard sending out an EpiNet message about the recommendations about treatment products, which came from the UK HCDO, which DH had not agreed to. And in the actual recommendations, Dr. Ludlam actually points out there that people should be wary of using unlicensed product. Now, I suspect that was more for the smaller centres than for the major centres, because the major centres were using it left, right and centre on the basis that they wanted the best product for their patients, and they couldn't wait the 2 or 3 years it might take to get it properly licensed. So therefore they were using unlicensed product. So I couldn't disagree with that.
Was it a concern, whether to you or to the department more widely, that unlicensed products were seemingly in widespread use for the treatment of haemophilia?
Well, the people in the department whom obviously it concerned more than anybody else were obviously MCA, which had which were the people in the department who looked after licenses, etc., and obviously the licensing authority, which was basically ministers, etc. But I think to a large extent, provided the product was only a small change from what had been there previously, then whether it was licensed or not, I never heard anybody in the department saying, look, we've got to close this down, this is just unacceptable. I think it was just accepted as being, this is at the vanguard, these are the people getting stuff through, a new thing, a better thing, they're trying to get it used for the benefit of patients. And the suggestion that these unlicensed products would pose a risk or be a disbenefit to the patients, I don't think that ever came into the equation, to be honest.
Now, I want to ask you next, Dr. Rejman, about the main areas on which you worked during your time at the Department of Health. If we start with the period 1989 to 1991,
yes.
2 areas in which you were heavily involved were in relation to the HIV hemophilia litigation,
Yes.
and the introduction of hepatitis C screening, and indeed
Yes.
the wider work of the ACVSB. In that period, 89 to 91, I'm not suggesting those are the only things you were dealing with, but were they the main things? Did they occupy most of your time, or were there other issues of equal importance?
I think they were the things that occupied most of my time, but obviously I had other meetings that I had to attend. And I think one of the points is that even if I might not contribute very much to an individual meeting, I think the important point was that if the department had an observer role at that committee, for example, say NEQAS or a task force from the British Society of Haematology, it was quite important for me to be there, to show my face, to show that we cared, to show that the department was taking an interest. Now, it might be that I'd go to the meeting and literally say nothing at all at the meeting. I might make some brief notes and get the minutes of the meeting next time round. But basically, I'd been there. I'd shown the department was interested, the department was listening to people. And I think this is part of the reason for attending committees. I mean, so I think there was one time, I think I did actually count it, that I was on 23 different committees at a given time. Now, obviously, I couldn't spend all that time on all of them. There were some things that obviously, like the ACVSB and the litigation, that were primary. And sometimes I might have to miss another meeting because, you know, there was a meeting with counsel or there was a court hearing or something, and I'd send my apologies. But I'd make sure that I sent my apologies so that people realised that it wasn't that I wasn't turning up there because I can't be bothered. And so I think, yes, those were the main things, but as I said, there were other things going on at the same time.
And then for the period 1992 to 1997,
Yes.
now some of the areas of your work that we'll look at was involved with the establishment of the scheme, the Eileen Trust, and the administration of the scheme in relation to those infected with HIV through transfusion or transplant. You had some ongoing involvement, I think, with the McFarlane Trust to an extent. You had some involvement in relation to Look Back.
Yes.
And towards the tail end of your time at the Department of Health, VCJD began to become an issue. And that was obviously a number of other issues, in particular HCV litigation and the issue of compensation for hepatitis C that you also had some involvement with. Were those, again, the ones I've mentioned, are they the main areas, or were there lots of other things that took up your time in that period 92 to 97?
Well, I think I've mentioned in whatever it is, paragraph 151, right at the very end, about my work as being medical secretary for the report on sickle cell and other hemoglobinopathies. That took up a fair amount of time during that period. And there was also that period, I can't remember which years it was, 92, 93, when I was covering also for transplants and tissue banking. So again, there were these bits that sort of took up time. And it was really a case of juggling everything and trying to keep the show on the road, so to speak.
Now, I'm going to ask you next then, in some detail about your involvement with the HIV Hemophilia Litigation. Yes. That litigation was already afoot when you joined the department in March of 1989. How did you become involved in the litigation from the department's perspective?
Well, in essence, I think that probably on the first day when I started, I think Hilary Pickles probably told me about the litigation and said, look, this is something you're going to have to get involved with. You know, that is it. Fact. No problem. And so I think fairly soon I started getting minutes from various people saying, look, this needs to be done, that needs to be done. And I think very early on in 89, we had the initial main statement of claim. And I think in my statement, I've actually gone through my various aspects of my role in the litigation. So one of the things that I had to do was to go through the main statement of claim, and then the amended, and then the re-amended, and then the further re-amended main statement of claim. And in essence, my role there was to read through the statement of claim, identify basically what they're saying, because I had to explain things to the departmental legal people, that's Ron Powell primarily with the HIV litigation, and also obviously to counsel, neither of whom were haematologists. And so I had to go through it, explain to them, look, this is what they mean by this, you know, and try and sort of get them up to speed so that at least they knew as much as they needed to know. And then, for example, I'd also go through if the plaintiffs included documents, scientific articles, etc., then I might have a quick glance through those and say, look, this is what this article says, and also say, have they said in the main statement of claim, have they actually correctly said what's in the article? Because sometimes they hadn't. Sometimes what they said in the main statement of claim did not actually agree with what the article said, or the article might say more than they've actually included in the main statement of claim. So in a sense, it was basically giving advice to, well, obviously also my administrators, but in a sense it was mainly the legal people that were more interested in this, but also so the administrators knew what was going on and trying to get them to understand what quite a complicated litigation was about. Because, you know, there were all sorts of aspects to this that had to be explained to them. So that was the main statement of claim. Then, when it came to the individual statements of claim, these were individual statements for individuals who had been infected. And I can't remember how many, well, I think in the end, I think there were about 1,200 or so infected. In the litigation, I think there's something like 900 or so. And I went through each of these individual statements of claim, and I prepared a brief pro forma, and on it I put down male. You see, there were some females. Most of them were going to be males, but occasionally there were females who were either haemophiliacs because they were the daughters of a haemophiliac and a haemophilia carrier, right? So therefore they were in the they could be, there was a small number of those, right? Or they were haemophilia carriers but had a lowish level of factor VIII and therefore might need treatment. And then there were also the von Willebrands, which were male and female were equal. So I put down sex, age, whether they'd had just cryoprecipitate or whether they'd had cryoprecipitate and factor VIII concentrate. If they'd had factor VIII concentrate, was it just NHS factor VIII concentrate, or had they had commercial as well, or had they only had commercial concentrate? And also, had they had heat-treated factor VIII, or was the infection before they'd had heat treatment? So all of these things I had to put together, and then I put these through on this pro forma, and I put this information into a database, which I think was called Cardbox, which was one of the earlier forms of databases. And so I put it all in there. And the reason for putting it there was because if the court case came to trial, we were going to have to sort out lead cases. And because obviously the trial wasn't going to look at each of the 900 cases. But what we need to have is we need to have somebody who'd had cryo and nothing else, somebody who'd had concentrate and nothing else, or NHS concentrate and nothing else, somebody who'd had just commercial concentrate and nothing else. So I had to put them into that. And also the time when they were first found to be HTLV3, as it was in those days, positive. Again, some in the early years, some in the later years, and some, the small number, who had contracted it from heat-treated factor VIII. So we had to put them into categories like that. So that was the reason for doing this. And I spent several months doing that. And I remember, actually, I think I did most of it at home. I took the papers home, because at home nobody would trouble me. So I could just sit at home, write it all out, get it all together, put it onto the computer, and it was there.
Now, we'll come back to some specific aspects of your involvement in relation to selection of experts and discovery exercises. But before we do that, however, can you just help us with understanding who the others were who were principally involved with the department, from the Department of Health with the litigation? So you've mentioned Mr. Powell from the Solicitor's Office.
The Solicitor's Office.
Counsel Andrew Collins and Justin
There was
Fenwick.
obviously John Canavan.
Yep.
He was the one that I worked with most closely on this. It was initially Mike Arthur as the HEO, but then I think it was David Burridge who was actually very much involved in this discovery particularly. Now, I can't remember who the EOs were at that time. Now, when it came to the Assistant Secretary, I think it was Charles Dobson, J.C. Dobson, Charles Dobson, I think was the Assistant Secretary when it was the HIV Hemophilia litigation. Now, obviously, Hilary Pickles had... Well, I copied her in a lot of the time when I sent out minutes, just so that she was aware that this was happening. How much she contributed to the discussions, probably not that much, because when it came to court hearings, for example, I would attend them, and quite obviously Ron Powell would attend them. David Burridge sometimes also. I don't think Hilary Pickles attended them. And then further up the medical management chain, I think Dr. Metters was aware. Now, how often I copied him into the minutes, not very often. Possibly if there was some very important thing going on, I might, but I doubt whether I've even copied him in. And obviously Charles Dobson would decide whom he'd copy in on his side. And then obviously we had our counsel, which was Justin Fennick, and there was a lady, and I can't remember her name actually, who was his assistant.
So would it be right to understand that in terms of the medical branch,
Yes.
it was mainly you?
Yes.
Now, I want to look at some documents with you.
Oh, sorry. The person, sorry, I forgot two other people that were involved, and that is from the MCA.
Mr. Kotowski?
Medicines Control Agency, which is now the MRHA or whatever they call themselves. Frances Rotblatt, who was a haematologist, and she had responsibility, I don't know what other responsibility she had, but she definitely had responsibility for blood products. And she actually commented sometimes. If I commented on MSCs, she might comment also. And there's also John Purvis, who was the pharmacist, Dr. John Purvis, who he was also involved in blood products, very much so in the European side of things, and he might also have contributed some comments.
I think we see some documents also refer to Mr. Kotowski.
I think he was probably in the AIDS unit at that time, because the AIDS unit, obviously, they may well have had some, well, they were interested. How much they got involved in the litigation, not that much, but they had a peripheral interest and they might be copied in.
Now, I'm going to ask you to look now at a handful of documents with me, Dr. Rejman. If we start with MHRA 00-17642. Now, this is one of two documents which purport to be a statement from you in the context of the haemophilia litigation. We can see that, I think, from the second sentence. And this sets out a series of comments on articles. I'm not going to go through the detail of them. If we go to page 6, it should be the last page, we can then see the last document that's referred to is one headed Precautions Against Acquired Immunodeficiency Syndrome, and there's some details set out. And then the very last sentence on this page says, we will need to check within the department as to whether anything was done as a result of these precautions advised by CDC. Now, what's your recollection, if any, of these documents? There's another version which I don't need to bother looking at.
Yes, well, similar. I think I have in my statement said, you see, this has been purported to be me as an expert witness, and I have said that is just not true, because the department would not use its own officials as expert witnesses, ever. And what my reading of this document, and there's a second document which has some corrections in it, because this has a lot of errors in it, including how to spell my Christian name. Basically, reading through this, it looks as though somebody has supplied several articles from the Lancet and asked me to make a comment on them. Now, I do not know whether this document is a secretary typing up from a taped conversation I had, or whether she actually she or he wrote notes at the time. But obviously, on the front page where it says statement from me saying what my function is, my guess, and that informed guess, is that this would have been an early meeting between me and counsel. And at that meeting with counsel, when I was introduced to counsel, I would have explained who I am. I'm an SMO in DH. And it isn't a statement from me. It's me speaking to council and saying to council, look, here's a group, and I don't know who actually chose these particular articles. That's the other thing that's not clear from this. You see, possibilities are these articles might have been articles in the first main statement of claim, and I've been asked to comment on them, which is what I'm doing. And if you read through it, it's very much a commentary, chat commentary. This is not something that's going to go to a court of law, because if reading through it, some of the familiarity, etc., isn't, you know, you wouldn't put that in a court of law report at all. So my guess is that a secretary typed this up. I had a meeting with council in the very early stages. Somebody, whether it was from MSC or whether I was asked, can you look in the Lancet and find some relevant documents? I don't know, doesn't say. And basically, I've just commented on them, and this is a chit-chat. I mean, so, okay, it wasn't held in a pub, but it could just as easily have been held in a pub.
And just looking at that last sentence, what's recorded here is we will need to check within the department as to whether anything was done as a result of these precautions advised by CDC. Now, my question is not about the substance of that, but whether any investigations were carried out. Who within the department would have undertaken those checks? Would that have been you or Mr. Powell in the solicitor's office?
Well, I think it depends upon precisely...
So it's specifically a comment in relation to the article Precautions Against AIDS, and we can see under the heading it refers to precautions recommended by CDC in the US.
Well, I think it presumably would have been administrative colleagues, well, AIDS unit probably first, because they would have been the one that would have known most, particularly because this is talking about, I can't remember what year this is. This is in 82, 83?
The article is, I think, January 83.
Right,
but that's a guess based upon the dates of the other articles.
So well before my time. So the chances are that I would not have had any of the relevant documentation. The AIDS unit obviously would have had. Now, the admin people, if this was well, this is talking about clinical and laboratory workers. It's not talking about haemophiliacs. So basically, the other people that might have been involved might have been the microbiologist in Med SEB or whatever it was at that stage. She might have known, I think it was a she at that time, might have known whether anything was done at that time. So, as I say, it would have been, I would have presumably asked my admin colleagues, and I would have said to John Canavan, look, council has said, because that thing at the bottom seems to suggest to me it wasn't me that thought that we should need to check. I suspect council said, look, this is something that they've raised there, and you know, this is something that perhaps somebody ought to check up about. And when it says that we will need to check, I presume council said, look, you've got to check this up. So I'd probably have gone to John Canavan and said, look, council has said this, can we check with AIDS unit, check with the microbiologists, were they aware, did they do anything?
I'll come back when we look at some later documents to the kind of investigations that were being undertaken for the purposes of the litigation, but we can take that one down. I'm going to pick things up then in May 1989 at DHSC 0029810, please, Paul. Now, this is a minute from you to Mr. Powell in the Solicitors Department of Health Solicitors Department, 31st of May 1989. We can see the heading AIDS Litigation Scotland. Just before I ask you about a couple of the passages in this this particular minute, more generally, what if any involvement did you have, or what if anything did you know about the litigation that was ongoing in Scotland, the parallel litigation, so to speak?
I really had very little knowledge. I mean to say, as we've said, there is some other reference to something. Oh, that's right. It was about one of the, was it the Eileen Trust or something like that? They said that they needed a different scheme for Scotland, and it was said there, well, Scotland has a different legal system, and that is why they need it. So I assumed that the Scots were handling this litigation themselves, and presumably at a higher level there was discussion. Presumably counsel, Justin Fenwick would be discussing with counsel in Scotland, and probably there were a lot of common themes, but presumably the Scots, looking at their legal system, might say, well, under our legal system this causes a problem. Does it cause a problem for you in England? And Justin Fenwick might say, no, because we have this difference. So I would not have been really very much involved with Scotland.
And then if we look down at paragraphs 3 and 4,
yes,
you refer in paragraph 3 to, in the UK, Haemophilia Centre directors encouraging patients to continue to use factor 8, because in their view the risk from bleeding episodes outweighed the risk from AIDS. And then in paragraph 4, you set out factors that might be relevant to using treatment other than factor 8 concentrate. And if we just go over the page,
yes,
we can see that continues. And then you say, needless to say, the final decision on treatment would be based upon the clinical judgment of the doctor concerned and on the informed consent of the patient. And then you go on to set out some alternative treatments.
Yes.
Now, are you able to assist in whether that analysis here was based upon your own knowledge as a haematologist who'd had a little bit of involvement with haemophilia patients, or whether you've got that information from elsewhere, and if so, what your source might have been?
Well, I think to a large extent, comments like that will be based on what I picked up at meetings of the UK HCDO. Because, as I say, my direct involvement with haemophiliacs was very small indeed. I mean, say, when I was at Thomas's, I was on the haemophilia unit, but as I think I mentioned, most of the time when I was actually in that part of the department, you spent your time, dosing people for warfarin, which was that took a lot of time, and advising on thrombotic problems, DVTs, pulmonary emboli, etc. And the haemophilia was very much a small part of that, very much a small part of that workload. And when I was at Guy's, again, small number of patients, very busy doing other work. So my involvement in haemophilia treatment was very small indeed. So I wouldn't be saying that on the basis of my previous experience of haemophilia treatment. This would have been on the basis of going to UK HCDO meetings, chatting to people, at lunch after the meeting, or when, so basically what I got from the haemophilia directors.
And then I read out that sentence which refers to the informed consent of the patient. Would it be right to understand from that, and indeed as a clinician yourself, you would have appreciated the importance of informed consent?
Yes. Now, I think the thing really is that this was a long time ago, and since then we've had all sorts of reincarnations of consent forms, both for surgery and for anything and everything else. This would have been, 30 years ago now, just over. And in those days, informed consent might have been a haemophilia doctor saying to a patient, look, I think we need to give you factor 8. Is that okay? Nobody signs anything. A day later, the patient wouldn't remember, well, did he actually say those words? Don't know. So I think when one talks about informed consent, I think what I'm talking about there is saying to the patient, look, we're using this factor 8, it's good stuff, works well, been used on thousands of other people elsewhere. Are you happy with it? Or he might have just said, well, you know, this is what we're using today. Cryoprecipitate is no longer used because it is so difficult to handle. You can't take it away. When you go on holiday, you can't take it away with you. If you want to go on holiday, you want to have a life, the concentrate is for you. You can go to work and you're no different from a diabetic. You know, people go to work, and how many people know that their colleagues are diabetics? They don't, because it's not as though they're giving themselves an injection of insulin in front of everybody else. They go to the loo or somewhere, close the and give themselves an injection. Nobody knows. And similarly with factor VIII concentrate, none of your colleagues need to know you're a haemophiliac at all. Whereas if you're having cryoprecipitate, and particularly if you're having regular bleeds, etc., then everybody in your department's going to know you're a haemophiliac.
So is it right to understand then from your answer that when you referred here to informed consent, you were not expressing a particular view or understanding about what information should have been given to patients about risks?
No, and to me, when I'm talking there about informed consent, it's a sort of generality that, particularly when I'm suggesting that the person is going to use a different thing. And you see, I've said there, say some of them you wouldn't use anyway. Blood you wouldn't use any, it's a waste of time. Even FFP is a waste of time usually. Cryo and DDAVP were the two relevant things. And I suspect that if a haemophilia doctor was going to change somebody from cryo or concentrate onto DDAVP, he'd have to explain, because after it's a completely different substance. And I think usually, if there were a change of substance that was being used, then I think at that stage, the doctor would spend more time explaining what was being done and why it was being done.
Did the department, to your knowledge, ever seek to ascertain or gain some understanding of the extent to which patients had or had not been given information about the risks of concentrates?
I do not believe at my stage that anybody asked that specific question.
Or the alternative treatments that might be available, the options.
Well, I think a lot of this was down to clinical judgment of the doctor. I think the problem is, I, as a non-haemophilia expert, cannot advise a haemophilia doctor, look, I reckon you should do this as opposed to that. Not in my remit. I know that there are alternatives. I know that there are advantages and disadvantages of various treatments. But ultimately, it's the doctor who has responsibility for that patient. He or she has to make the judgment. What is the best thing I can do for my patient in the situation we are in at this precise time? And the doctor, and I think this is the thing you see, none of these doctors were people saying, oh, well, we'll do this, that, and the other. They were all thoughtful people. They knew that there was a lot of possible alternatives. They looked at the patient, they looked at the situation, and they said, look, in this particular situation, taking everything into account, and obviously they knew these patients very well, because they, because the number of patients they had, even if they had 200 patients under them, that was a relatively small number compared to a general haematologist who might have thousands going under his care during a given year. So they knew the patients, they knew them well, very well, some of them. And they would actually say, well, look, I know you, I know your history, I know what we've done in the past. I think that taking everything into account, I think we ought to change and use this different treatment. And then also, if there were a new treatment that came from a drug company, which was supposed to be better, then they would say, look, we've got a better drug for you. And that's why the label on the bottle is different. And obviously this was very important for those patients who were on home treatment, because they were the ones that would actually look at the bottles and they'd say, oh, look, it's a different name on it. Why is that? And they'd go back to their haemophilia doctor and say, look, why have you given me a different name?
Thank you very much.
Thank you.
Now, I'm going to ask you to look next at a document from June of the same year, June 1989. Paul, it's PRSE 0002656. And you'll see from the top, if we can just zoom in on the heading, these are minutes of an extraordinary general meeting of the UK Haemophilia Centre directors to discuss haemophilia, HIV and litigation, 16th of June 1989. And we'll see down the right-hand side, you're there, although you're there as Andrzej Rejman rather than as
incorrectly.
Dr. Rejman.
Yes.
And then if we look down towards the bottom of the page, we can see under the heading Introduction, Dr. Ritzer welcomed the participants to the meeting, especially the representatives of the medical defence organisations and Department of Health and the legal advisors from various health authorities. So this was a meeting involving not just the Haemophilia Centre directors, but as we see set out there, yourself, legal representatives and medical defence representatives to discuss the litigation. Now, I just want to ask you about a couple of issues that arise in the minutes. If we could go, first of all, Paul, to page 6. Now, this is headed the Scottish position, and there is an account given by a Mr. Griffiths of the Central Legal Service for the NHS in Scotland. I'm not going to ask you about the detail of what the position was in relation to Scotland, but if you look, if you keep it where it is, Paul, on the screen, if you look towards the bottom of what you can see on the screen, Dr. Rejman,
yes.
I hope you'll see a sentence saying the defendants would say that they could not have been aware of the virus risk until mid-1984. So that appears to have been the position being taken in Scotland, at least as related by the Central Legal Office in this meeting. Do you recall whether that was the position taken by the Department of Health in the litigation, or whether the Department of Health took a different point in time as establishing knowledge of the virus risk?
I would have to go to the papers to find out. I really don't know.
And then if we go on, please, to page 12. It says at the top of the page, the question is posed, should the directors put pressure on the government to provide compensation? Dr. Kernoff agreed that the directors should do this and should draw attention to the great amount of extra work generated by litigation and how this extra work was detracting from patient care. Now, you were, as you've told us, the main conduit, as it were, between the UK HCDO and
yes.
The Department of Health. Do you recall whether following this meeting the directors did take any particular steps to put pressure on the government to provide compensation?
Well, all that I can say is that at a number of the meetings, people did keep on pushing for the department to pay up so that the litigation would finish. And, that was the way it was. Whether they ever actually formally wrote to the department, they may well have done. So I don't know. I cannot recall a particular letter I can't recall, but it may have happened that a letter came to the department and I was asked to comment or whatever, but I can't remember. But yes, they did. They applied pressure in the sense that they had a go at me when I went to their meetings, and they said, look, we really want you to finish off with this litigation. It's not only detracting. Well, say Dr. Kernoff, Professor Kernoff, who, as you know, is no longer with us, sadly, when he talks about detracting from patient care, I think he could also have said, and also stop them litigating against us, because a number of haemophilia doctors were being sued individually.
So is this right then? You recall individual doctors making oral representations to you, as it were, at the meetings or in the discussions about why won't the government pay up. But you don't recall anything by way of some kind of formal approach or campaign?
I don't think so. You see, I think, you know, the way it came across was that, you know, I'd go to these meetings and, you know, one person would say something, somebody else would say something, and, you know, it became quite obvious to me that the haemophilia directors really wanted this closed down as quickly as possible. And, you know, so there's no denying that. And I think if you read through some of the minutes, you know, reading, not even having to sometimes read between the lines, just reading the lines, actually, that comes across that, you know, they were not best pleased with the department. But I think, you know, my answer and the thing that I kept on saying on a number of occasions was that the department was defending against claims of negligence, not only, well, primarily against the Department of Health, particularly once they'd removed the CSM and the licensing authority from it, but also, in a sense, in fact, protecting the doctors. And I said that, you know, it was a case of negligence that was being brought against them, and the department was defending against that.
It's right to note that you produced your own minute setting out your account of the meeting. It's at DHSC 0003670_002.
For the sake of the transcript, there's a 0 missing.
Oh, I'm sorry.
In the title, it's 003670 should be.
Thank you, sir. So we can see it's your note to Dr. Pickles, copied to others, on that meeting on the 16th of June 1989. I just want to draw your attention to 2 points and then pick up the theme of one of them at a later stage. But on the issue I was just asking you about, if we go to page 4, bottom of the page, we can see it said several doctors suggested that a no-fault compensation scheme should be available. And then top of the next page, so paragraph 19, you describe several doctors suggested that the financial and manpower considerations should be put to the government and that pressure should be brought to bear on the government to sort out the problem. And you refer to Dr. Jones, Dr. Hill, and then to Dr. Bain saying it had been government policy not to speed up production of Factor 8 at Elstree to become self-sufficient in the late 1970s. So is that the kind of way in which this issue was raised with you by doctors, by the Haemophilia Centre directors?
Well, yes, but I think later on at the meetings they didn't mention financial or manpower. It's basically a case of we don't want... Because you see, I think one of the problems was that some of the haemophiliac, well, they felt that they as doctors were being got at by the haemophiliacs because the government wasn't paying up. And I think that was one of the reasons why, apart from them being litigated against as individuals, they also felt that their relationship with the haemophiliacs was not as good as it had been previously, because the haemophiliacs were jumping up and down saying, look, we want our money, and the doctor could do nothing. All he could say is, well, you know, not me, it's the government. And I think, you know, it was a sort of a mixture of various comments during the 2 years that the litigation happened.
Now the reference there, financial and manpower considerations, you referred to a further one, which is the doctors themselves being sued and finding that difficult. Do you recall whether the Haemophilia Centre directors, either collectively or as individuals, ever sought to make out a case to you based upon the appalling suffering that individuals were undergoing?
I don't think they did, and I don't think they needed to, because I think the point is that people in the department were well aware of what difficulties HIV had caused. Because after all, we realised initially, as I've said in my statement, the initial assumption was that all the haemophiliacs that were infected with HIV would be dead within a couple of years, because that was what was happening to the initial people that had AIDS in the States, and they had died very quickly. So that was the assumption. So everybody knew these are people that are seriously ill. They may not have much time left to live. And so everybody in the department was aware of that, as were the lawyers involved, as was counsel and everybody else. You know, so I don't think there was I don't think the haemophilia directors needed to say, look, these people are suffering, because we knew that. And if you read through some of the minutes, it's quite clear that, you know, we were aware.
The same month, so a little later in June 1989, there's a submission to the Minister of State for Health at MHRA 0017681. We can see, if we look at the top of the page, it's from Mr. Dobson, who you've already referred to the PS to the MSH, to the Minister of State for Health, 26th of June 1989. And then you're one of a number of individuals who are copied in to this document. If we then go to the bottom of the page, we can see what's said to be the purpose of the submission: to inform ministers of the legal action being taken, and then 2, to seek ministers' views on the case for resisting the plaintiff's attempts to produce by way of a group action. Over the page, top of the next page, to seek ministers' views on the question of ultimate liability, and then 4, to seek ministers' views on other options for handling the litigation and the controversy which it's likely to engender. So that's the purpose of the submission, but I just want to ask you then about a handful of things that are said in the submission, and to see whether you can cast any further light on it. I'm not suggesting you are the author of these passages, Dr. Rejman, but there aren't very many other people we can ask. So paragraph 2, we just zoom in on that, please, Paul. You'll see it sets out a summary, or what's said to be a summary of the position in relation to transmission of the AIDS virus. And then the last sentence says, officials involved at the time are satisfied that every possible effort was made to introduce the screening test as soon as possible. So that's the introduction of screening of blood for HIV, introduced in October 1985. Now, do you know what investigations or inquiries were undertaken to enable that statement to be confidently made?
Well, my assumption is that either Charles Dobson himself or somebody from his team or somebody else who actually told him, and presumably he may well have even asked the AIDS unit, which basically were the people most directly involved in that. And also Diana Walford was there at the time, and she was still in DH at that time, so presumably they could have easily have asked. Well, I'm not sure whether they would have wanted to ask her, because actually, when was this? Oh no, she was an SPMO. This was before she became a DCMO. They could have asked her, but I suspect they would have asked the AIDS unit, and basically the testing. The administrators in Charles Dobson's branch, or whatever the branch was before, because they kept on changing names, but whatever the branch was that was dealing with blood transfusion, they would have had all the information. So, and some of those officials, well, the point is, you see, in DH, a lot of officials changed jobs pretty quickly, and are only in the job for, say, a couple of years. I was actually in my job for a number of years, which is unusual, because a lot of people, during my time, during the years that I was there, I can't remember anybody else who was in the same job for that length of time, because people chopped and changed. So the officials involved might well still be in the department, but they were in a different department, so you could actually ask them, and also go to the files. So.
And as far as you can recall, and I appreciate it's a long time ago, but was that issue of the introduction of the HIV screening test, an issue on which you, in your involvement in the haemophilia litigation, were asked to express a view on or input into that assessment?
No, because in a sense, it didn't involve the haemophiliacs, because you have to recall that the time when the screening test was first discovered was in 1984, and we had heat treatment of factor VIII, which came in late 84, so pretty well much the same sort of time. So there'd be a very so the only haemophiliacs that could be affected by the delay or whatever, if there had been a delay in the introduction of HIV screening for blood transfusions in this country, would have been patients whose only treatment for haemophilia ever had been between October, well, actually, no, it's difficult. Well, okay, people who had cryoprecipitate, right? Okay, let's take the easier bit. If a patient had been given cryoprecipitate for the first time ever after, say, mid-1984 or late 84 and October 85, and they became HIV infected, then they could have said that that was because of the delay in testing blood transfusion in the UK. Anybody else, it wouldn't have affected, because the blood taken after 84, by the time it was processed, it would probably be processed by the time heat treatment came on board. Because it's not as though it was processed into the concentrate, next day or anything. It would be months or a year or so, sometimes even, before it was actually processed. So I think it would only have affected a very, very small number of haemophiliacs, if at all.
If we go to the next page, there's then a rather wider statement, paragraph 5. If we can zoom in on that, please, Paul. And I want to pick it up in the last 5 lines of that paragraph. We believe that the government has a fair chance of successfully defending its role in the court actions, given that at every stage it has acted as swiftly as possible to minimise the risk of infecting haemophiliacs with AIDS in the light of the best expert opinion available at the time. Now, Dr. Rejman, in a very general sense, the department might be able to say, we believe we'll win, because we believe the legal arguments about whether there's a duty of care are all in our favour, for example. And we know that was one of the issues in the case. I'm not asking you about that. But the reason given here is a factual reason. At every stage, the government acted as swiftly as possible to minimise the risk of infecting haemophiliacs with AIDS in light of the best expert opinion available at the time. Now, again, I'm not asking you about the substance of that statement. Yeah. My question is this. Do you know what inquiries or investigations or information the department had in 1989 upon which to base such a confident assertion of everything having been done essentially as well and as quickly as possible?
Well, I think you have to recall that this is June 89. Now, the litigation had already started, I don't know, sometime in 88. I'm not sure exactly when. Now, I saw the first main statement of claim, which was June 89, which is about this sort of time. But you see, even before that main statement of claim, people within the department and legal advisors and counsel would already have been starting to consider about, were there were there obvious things that had not been done where they would be found liable? Now, I wasn't involved there because this is June '89.
Yes.
So I've been in the department 3 months. So, you know, I've really had very little in any. I would have, by this stage, I think the first main statement claim would have been there, so I could have actually commented upon it. But to a large extent, I suspect this was based on those earlier considerations in 1988 and early '89. And I think Charles Dobson is basically saying, look, we've spoken to council, and council has said that overall he thinks that the case can be defended on the basis that people actually did their best at the time with the knowledge they had at that time. And the expert opinion would presumably have been opinion they got primarily from the UKHCDO, who were the experts in the field, and that might have been, whether they got any information outside the country or not, I do not know.
So the kind of statement that's set out here in June 1989 is a statement that's then repeated at various stages in the materials that you've seen. I'm not proposing to go through each and every example of them, where it says on a number of occasions words to the effect that we, the government, did everything we could as well as we could based upon the best expert opinion available at the time. Post-June 1989, and conscious, as you say, you'd only been in post then for 3 months, but did you ever gain an understanding of the investigations, the factual investigations that have been undertaken by the department, if any, in order to provide a basis for such an assertion?
Well, you talk about a factual investigation. I don't think the department ever set up and said to an individual, will you go through all the papers, etc., and give us your... What do you say? But that's what counsel is for, isn't it? Because basically what you do is you get snippets of information and you build them together and you say to counsel, look, this is what we did then, this is what we did then, this is what we did then, this is the advice we had, and this is what we did in the end. And counsel looks at it and counsel makes the judgment, yes, it looks as though you did roughly the... In detail, don't know, but you, generally speaking, you did roughly the right things that one would expect you to do at those times with the knowledge that was available at that time, and taking into account, you know, well, basically the knowledge at that time and what you were advised by outside experts. And so I don't think anybody ever did a formal review. Counsel, in a sense, was probably the closest we ever came to a formal review.
Thank you. Can we then look at...
Before we do that, can we just go back to the previous page, please? And paragraph 2, I want you to help me with the second last sentence. Particularly in view of your answer as to what the general view was about doing things as quickly as possible. You say this, picking it up at the third last sentence, this followed expert advice to CMO not to introduce screening for blood donors until the various HIV antibody test kits have been thoroughly evaluated with respect to sensitivity, picking up the cases, and to specificity, picking up the correct disease, so that an accurate test could be made widely available throughout the NHS. And then this was to avoid members of high-risk groups offering themselves as blood donors simply to determine their HIV status. Can you help with how that fits with the decision to delay screening?
Well, yes. My understanding, obviously I wasn't there at the time, this is my understanding from what I've been told is that there was a significant worry that people who knew they were at risk of HIV, primarily homosexuals, but also IV drug abusers, who wanted to know whether they were HIV positive. Now, why they wanted to know, was it to protect their partners or was it just to know that there was a risk that they would offer themselves as blood donors? Now, I know that if they actually stuck to the rules of what the blood donor leaflet said, they should not offer themselves as a blood donor. But to be frank, when a blood donor turns up, how can you tell whether they're homosexual? And you don't actually ask them to roll up their sleeves and look for injection marks. You know, you might notice that if you're putting a needle into that particular arm, you might say, well, look, you know, you've got all sorts of other injection marks here. What are they? But apart from that, these potential donors who could actually, because they were at such a high risk of HIV, they would undo a lot of the good of actually introducing screening. And, you know, say you had 1,000 of these people, and you could quite easily have had 1,000 of these people, or even 500 people, pitch up who are HIV positive, then that, and before you've got the test available, you know, that could have been a very significant effect on safety of recipients.
Now, it may be that it's unfair to ask you to comment on this, but it does look, and you pretty much confirmed it, that the decision not to introduce screening when it could have been introduced, but later instead, was, as you've just described, which is the risk that in some respects there may be so many people who actually were themselves suffering from infection, who didn't necessarily know it, who would come forward just to see if they were suffering from infection, so that even effective as the test might be, it wouldn't have been sufficiently effective to screen out more cases than it was letting through. So that's what you've just said, I think.
Well, I don't know. You'd have to look at the numbers. But the numbers of HIV positive donors who actually honestly excluded themselves because they were in an at-risk group, you'd have to look at how many HIV positives actually pitched up in October 85. And then you could say, well, look, is that number bigger or smaller than the potential numbers that could offer themselves as donors and who were positive?
Let me just ask Counsel, are we aware of any research having been done in 1984-85 as to the likelihood of the test being so imprecise that it would allow through more cases of HIV if it were introduced into the bloodstream than the leaflet would exclude?
Not off the top of my head, sir, but I would need to double check.
I haven't seen any document myself on that, but I'd be welcome if any core participant knows of one to see if that risk balance was ever struck. Otherwise, this is a reason. The reason I ask is that this is a reason given for a deliberate decision to delay a test which might have been introduced sooner.
Yes.
Thank you.
Just before we break for lunch, Dr. Rejman, I hope only one further document. DHSC 0006272_043. This is a minute from you to Dr. Pickles dated the 13th of July 1989. The topic we can see from the first paragraph refers to, I think, the Oxford Regional General Manager having made comments about lack of cooperation between the Department of Health and the regions over the litigation. Paragraph 3 refers to a meeting attended by Mr. Dobson, Mr. Powell and Mr. Gutowski, where it said it was felt the cooperation should be sought as to fact and as to release of documents which would be relied upon by all the defendants. So that's the background. What I wanted to ask you about is part of what you say in the next section. So you say you refer to a letter, and then you say we're still awaiting a reply to Mr. Dobson's submission to ministers, which is the document I think we've just looked at. And then you say this: in the meantime, we would suggest, and then there's a reference to Department of Health meeting with the representative of the RHA defendants, Paragraph 2 refers to spelling out the precise interests of the department and the health authorities. Paragraph 3 refers to agreeing a common history and set of events. And then over the page, and it's over the page inevitably that I want to ask you about, the next paragraph says, DH does not make available to the RHAs, DHAs any information which might be used against the DH, although some of these documents might be shown under privilege to RHA/DHA's counsel. First of all, Dr. Rejman, why is this suggestion emanating from you? Because it doesn't appear to be a medical matter at all.
Right, sorry, could I just have a look at the top of the document?
But of course, if we go back to the previous page, please, Paul.
Right, okay, yes, okay, so it's copied to Dr. Metters, who at that stage was the SPMO of our division. Mr. Dobson, who's obviously the administrator, and Mr. Canavan. And I suspect I am reporting back to Dr. Pickles what the administrators have said, because I think, and also to Dr. Metters. My guess, my assumption is that this had been discussed with Mr. Powell, definitely, and with Charles Dobson and Mr. Canavan and Mr. Arthur, who was then the HEO. And having had that discussion with them, I obviously wasn't at that meeting where they referred to Mr. Dobson and Mr. Powell, etc. But presumably, I have got this information from the administrators. I am now passing it up my medical line and to Dr. Metters, because one of the things is that obviously Dr. Metters would have contact with this particular, possibly not with the regional general manager, possibly with the regional chairman, other people within that region. So it's really a case of passing information that I have been given to Dr. Pickles and to Dr. Metters so that they are aware, so that if this comes up in conversation, they know what has actually been happening. And as you see, I've just marked it in confidence, because obviously this is something that we wish to keep, within the bounds of the people that need to know.
And if we go to the top of the next page, that assists us in understanding why it's coming from you. So as I understand it, your evidence is it's not your idea, you're reporting what's been agreed by others.
Yes.
But if we go to the top of the next page, are you able to assist us in understanding why it was the Department of Health was apparently unwilling to make available to the health authorities information which might be used against the department?
Well, that presumably came from Ron Powell and the administrators, because at the end of the day, I haven't given there any sort of indication as to what type of information this might have been. And as I say, reading the minute, I assume I'm passing info. You see, we were discussing earlier on the business about the benefits of having parallel hierarchies, the advantages and disadvantages. Now, obviously, if we had a merged hierarchy here, this minute would not have been sent, because the people that need to know would have known because they're part of the same group. But because Dr. Pickles and Dr. Metters are not part of the group, and obviously I've copied Mr. Dobson, Mr. Canavan, etc., so that obviously if they feel that something that I have reported to Dr. Pickles and Dr. Metters is inaccurate, they can then send a subsequent minute saying, Dr. Rejman has misunderstood this. In fact, this is what we had agreed.
And then, so that we don't have to come back to this document, can I ask you about the last paragraph in the document?
Yes.
Which reads as follows: DHA/RHAs, so that's district health authorities, regional health authorities, be told that no extra money is to be made available to them from central funds. In this way, the DHA/RHAs will be encouraged to defend the actions. It has been made clear to us that the Haemophilia Centre directors, as well as the DHA/RHAs, would like the government to pay compensation without the need for any further legal action, and they're encouraged in this by the Haemophilia Society. They do not appreciate that the total cost would be at least 1,200 times 250k equals 300 million, 300 million then set out in capital letters in brackets, as well as the risk of such compensation being extended to benzodiazepines currently the subject of litigation, Sellafield, etc., etc. Now, a couple of points, if I may, Dr. Rejman. First of all, is it right to understand that what you're reporting here is a positive decision by the department to try and ensure that the health authorities defend the actions? They don't settle the actions brought against them by plaintiffs?
Well, my reading of it is, as I say, I cannot remember this minute at all. My reading of what it says there would actually suggest that, you see, I think the thing is that the health authorities are a group of different health authorities who have different views, but in a sense, they're forever trying to get extra money from the department, whether as an individual health authority or all health authorities together. And here, presumably, somebody somewhere had suggested that perhaps the department could cough up some money so that the health authorities well, it doesn't actually... Well, actually, there's a non sequitur there, isn't there? Because it doesn't actually say what the extra money is for. Because if it is to help them defend the actions, you would have thought we'd say, yes, we'll give them some extra money to help them defend the actions. And that's not what's said there, is it?
No, I mean, this reads, and I appreciate you may not have been the originator of the decision, Dr. Rejman, but it's your note, and hence I'm asking you.
Yeah.
This reads as though, whatever precisely the money might or might not be for, the department has resolved that it wants the health authorities to defend the actions and has identified a means of essentially ensuring that, facilitating that, by withholding or not making available any additional money. I mean, that's the, whatever the mechanism precisely, that's the objective that's clearly spelt out, is it not?
Yes. As I say, I cannot remember this at all. I mean, say, my reading of it is that I had a meeting, whether it was just with Charles Dobson or with John Canavan or whatever, when all of this was discussed. And presumably I made notes of our discussions. And I usually was quite careful to make notes of discussions because I couldn't rely upon memory, because these sort of things, you know, you can't remember. You have to really write them down at the time. So presumably I would have written this down at the time. And as I say, if what I wrote was inaccurate, like, for example, the business about the extra money, etc., then that presumably Charles Dobson or somebody would have written to Dr. Pickles and Dr. Metters and copied me in and said, look, Dr. Rejman has actually got this wrong. What we meant to say was so-and-so. And obviously, because it's talking about extra money and all of that, that obviously wouldn't have come from me remotely. You know, that had to come from the solicitors. The one thing that I would have known about would have been about the £250,000 per head, because that was common knowledge. I knew about that, as did everybody else. About the benzodiazepines, well, sorry, that's incorrectly spelled there. Benzodiazepines and Sellafield, etc. Again, that would have come from the solicitors or from admin, not from me.
Is it, I mean, it looks as though you've chosen to put, but this may be unfair, perhaps you're recording something that someone else has written, but the 300 million in capitals looks like it, or might be said to be you spelling out the financial consequences. Is that
That's
fair?
right. Well, that was spelt out to me, presumably, and I am just passing on the message. And as I say, reading this minute, I think, you know, there's a lot of that would not have come from me initially, because I would not have been in a position to think about it or present it. So that is my assumption, is this is a report of a discussion I had with Charles Dobson and with John Canavan and with Ron Powell. And I'm just relaying this to Dr. Pickles and Dr. Metters so that they are aware, so that if they, in their own turn, they may get a letter from the RHAs about this, and so that they know what the background is.
So I note the time. I'm sorry again for making inroads into everybody's lunch break. But if we could break for lunch now.
Well, we'll take a break until 2:10. 2:10.
Thank you.